Welcome everyone to the third and final Zoom session for the cyber course. Lovely to have you all join us today. So I'll just go first through what the class should be covering this week for week 10. So for lawyers and judges, this week is all about the final task of completing the case study, which you can complete in your own time. For law enforcement, this week is about finishing all of the content before the case study. The final module is all about what things a digital forensics report needs to contain. The ultimate goal of the case study sessions is for everyone to gain a shared understanding of how police and prosecutors can work together to effectively gather and utilize relevant digital evidence. For example, last Zoom session was about investigations, but both groups are included to help you build your understanding of the entire history of the case, from the initial complaint right through the conduct of a trial, if a matter progresses to that stage. This week, this session is focused on prosecutions. We're hoping this session will help you to understand how the conduct of the investigation and any digital forensic analysis that has been conducted has real implications for the conduct of the trial. And for our police participants, we are hoping you will gain insights into how prosecutors approach their task of preparing the case for court to assist with future engagement. Would anyone like to comment on what you thought was interesting about the previous session so far? I can see a few hands up saying it was good. It's good to hear. Okay. Alrighty. So thank you for your contributions last session. So what we know so far is, based on the outcomes of our pre-trial meeting, the lead investigator took Kai's laptop and submitted it for forensic analysis. The forensics analyst confirmed that Kai's laptop did have software installed, which synchronized the passwords to Bob's phone without Kai's knowledge. However, we know that Bob deleted data from his phone when the police came to his house, and unfortunately, the forensics examiner was unable to recover anything from his phone. The investigators also obtained CCTV footage from the library and obtained a printout of the browser history, which has been included in the evidence brief. As a result, the prosecution is now working through the witness statements and the available digital evidence and thinking about how the prosecution case might be challenged. You might recall from last week that Bob has been charged on 2 counts: Article 2, illegal access, and Article 8, computer-related fraud. For this session, you will consider these 2 charges for 15 minutes each. I do just want to mention one area where we might have changed the brief so it doesn't match what would happen in a normal case. You might have noticed that the digital forensics examiner, Ronald, will be called to give evidence but hasn't provided a statement. Ordinarily, it would be unusual for a police witness not to give a statement unless their evidence was really unimportant. The prosecution also can't ordinarily call a witness to give evidence at a trial unless that witness has first made a statement and that statement has been disclosed to defense. I will now hand over to my colleague Amit to go through the questions with you for today's session.
Thanks, Cara. Hi, everyone. Pleasure to be here. So for today, your task is to review the witness statements provided and match parts of them up with the elements of the charge you're considering. So the first question is, for this charge, depending on the charge that's being discussed, what are the main issues of reliability, admissibility, or relevance that might arise in relation to each witness's evidence? The second question is, what aspects of this evidence would be most persuasive to a court or jury, and where you might need to support the witness with reference to the digital evidence included in the brief? And the third question is, what would the defense choose to cross-examine your witness on? How can you prepare for this through evidence in chief? As a bonus question, how will you handle the sensitive material which has been mistakenly included in your brief of evidence? So before I throw back to you all for the discussion, I just wanted to define a few terms so we're all on the same page. In question 1, when we talk about relevant evidence, we're referring to evidence that is relevant to the elements of the charge and also to any fact that you think will be at issue in the case study, including facts relevant to the admissibility of other evidence. When we refer to admissibility of evidence, we're referring to evidence that can be admitted to court under the rules of this jurisdiction. This can differ, so feel free to talk about the rules which may apply in your jurisdiction and identifying any common concerns. Finally, when we talk about the persuasiveness of evidence, there might be a range of reasons why evidence is persuasive. For example, this could include if the witness seems to be trustworthy and reliable, if the evidence is not inherently unreliable, if there is other evidence which corroborates or supports the witness evidence, or where the prosecutor can make a compelling argument about why the evidence should be accepted.
Cool. Does anyone have any questions so far about that? No? Okay, we'll continue. So now it is time to open up the case study and evidence brief again, if you have them handy. The intention for this session is that you will go through the questions together, and AGD, CDPP, and AFP staff will help you with any questions you might have. I also want to remind everyone again that these case studies are not graded in any way, so this is an opportunity to ask any questions you might not normally ask and share your thoughts. So we'll start with a discussion of charge 1, which is on Article 2, illegal access.
If it helps, Cara, I can jump in as a prosecutor in Australia, and
yes, that would be Natasha.
what we
Welcome.
would do. And then if participants want to chime in, I'll also maybe throw out to everyone along the way. One of the first things I always do is when I go through a witness statement is first of all determine how is it relevant. That I even jump to that before I get to questions of reliability and admissibility, and then from determining the relevance of that witness's evidence, I then will make an assessment about the reliability and admissibility. So potentially looking at Maria, she's one of our key witnesses, and when I prepare, literally go through with a highlighter. Some of my colleagues have now started using iPads, but I live in a world where I like a piece of paper. I probably suspect that many others still do that. And so for me, Maria is going to be relevant to identifying the crime, but also identifying that Kai's Facebook was used, and that evidence that he was speaking in a differently, or sorry, writing effectively differently, spelling mistakes that she wouldn't normally expect him to have done. And also that when she confronted him, he was very upset. One thing that does leap out to me is in the witness statement, we've got what we would call secondhand hearsay. That is that Maria recounts that she was told by someone that the boys were looking at her images online using an app she'd never heard of. And I'm sure this is something that the investigators really struggle with, is how do you get that secondhand hearsay, and how do you deal with taking statements and whether you include secondhand hearsay or not. In Australia, I could have this evidence found to be admissible if I called that friend to give evidence as well, so that we have a provision under our Evidence Act that if the maker is also available, then they are able to give that evidence. So I would call the friend to say that she had a discussion with Maria and this is what she said to Maria based on her knowledge. Now, I not to pick on the first person, but Sergeant Starr has his camera on, and I think this is the Nauru Police Group. And whether they had any microphone. Oh, thanks, Simon. I was going to pick on Sergeant Starr or whoever's from the Nauru Police Group that's got their camera on as to what issues you looked at or have seen from, maybe I will go to whichever witness if you've had a chance to have a look, and what you think is something that jumps out at you as to either the relevance or why you think police have taken a statement maybe from the librarian, and what issues you think a prosecution might see. I don't know, do you guys have you're muted, but with the librarian statement, why do you think police officers would have taken a statement from the librarian?
Yeah, fresh. I think because she's the like a fresh witness or something like that.
Yeah. The great answer. It's I think this is one of the areas where it can help investigators and prosecutors where investigators, when they're taking those statements, step through, okay, how is this evidence going to be relevant? So as you say, she's been the one to see what we will say is Bob doing stuff in the library. Do you think that there's any issues going to be arising with her reliability or credit?
Well, she will know what Bob did actually on that computer, but the thing she knows is that the time and yeah, the computer he used at that time.
Yeah, definitely.
She react. What was the first reaction of the victim?
The other one that concerned me was that she writes in her statement that she was busy stacking books, so wasn't paying much attention. And I can see a defense really jumping in on that to say and start a cross-examination line that she couldn't have picked up all these details if she wasn't really paying much attention. So this is something that I think would definitely need to be considered as to her reliability and the credibility of her. Now, if I turn to someone else in the group, thank you, Naru, please. With Eric, who's our informant, what relevance and issues do we think will arise with his witness as evidence? I'll start calling out names. Maybe if we look at Simon, is there anything that jumps out to you? I don't know if we have Simon online. If not, I might throw over to Peter Hancock in the AFC, who probably hasn't even read the brief. He may have, to say what he thinks that the informant, or actually I'll throw you a bone, Peter.
Yeah,
What
please do.
issues?
I haven't read the brief, I'm sorry, but yeah,
That's okay.
ask away. That's good. I'm here to
What
sort of give
issues do you-
advice on things. So
Yeah, the forensic examiner. What issues do you think? Well, granted, we don't have a statement from him, which is probably the first issue that we have. In Australia, that simply just would mean that they weren't able to be called as a witness, particularly an expert witness. But he's confirmed presence of hacking software on Kai's laptop and analysed both Maria and Bob's phones. What issues do you think are going to be arising in relation to either admissibility or reliability for the purposes of showing that there was illegal access?
yeah, I mean, obviously the key issue is, you know, can you identify or can you put the person to the user of that computer, but without actually having, you know, sort of CCTV or a camera on top of that, you know, pointing down on the computer. It's always a hard question is, you know, how do you know, Mr. Hancock, that, you know, my client was the actual user of this computer? How do you know that my client was the person that installed this software and deleted this software, all these accusations that have been made? And, you know, sometimes you just have to, you know, concede that, you know, yes, Your Honour, that is possible, that it may have been someone else who installed, you know, that software. When we know that potentially that might be an issue, like we try and get as much attribution data as possible when putting together our analysis and our statements. We usually try and tie up, you know, internet history records that might be relevant to a user and their social media account. So it might show when they were accessing a social media account on their computer at the time, which might line up to that internet history or those installation dates. So you can then say that, you know, this user of this Facebook account, for example, was accessed at the same time as, you know, this software was installed on this device. So you can start putting together timelines. So timelines are a pretty important piece of evidence when doing analysis. I mean, you're still doing it in a you know, in a non-biased way, but painting a timeline might then obviously, you know, corroborate with what the investigator has for knowing that the suspect was home at that time and may have been the person using that computer. So I guess dates and times are a pretty important thing as well. So when given evidence in court, I make sure that I know that when I did the examination that I did the proper date and time check, you know, doing the BIOS checks, to then corroborate with the timeline that I have for that device. There's also a lot of things that might potentially, you know, discredit date and time based on the type of, you know, device it was, and, you know, other devices connected to it, these kind of things. So yeah, there's a variety of different things that might get contested in court. Is there anything sort of more particular that you were hoping for?
No,
an
that's
answer?
great. And I think that leads us to probably question 2, but also, which is what evidence is most persuasive? And this is something that I think both investigators and prosecutors generally use, is the timelines and the time chronologies. And it can be really useful for a court and a jury if we can present it as a timeline as to when pieces of evidence were obtained, or, you know, when someone created a profile or created something. Now I see Michael has his hand up, so I might switch over to Michael.
Yeah, I'd like to just add on what Peter said. The installation of the software, the checking the USB or what's been connected to the computer will give you dates and times of anything that's been connected around the time of the installation. And if you find that particular device or devices in the possession of your main suspect, that then gives you a further corroboration, because you can then look at, well, that device was connected, it's yours, it's got the software on it, and the software was installed at this time. So that can add to all the rest of the evidence that Peter mentioned.
Yeah, and the great thing there is then, as a prosecutor, you then take the statements of, say, the librarian who says she sees someone with various applications open. We have the CCTV footage, which can then be lined up with the visual recognition of Bob and how it matches Bob. And then we also have printouts of browser histories and when various applications and browsers were open. And one of the really key things here is that whilst we don't have direct evidence, circumstantial cases can be very, very powerful. And once you draw all those points together for a jury or a judge, that's where you can easily prove a case. And so all those little minutiae and the little details that the investigators are getting, the prosecutor is then able to compile them all together to really draw out an overwhelming case. If I can throw it out to our last question, noting the time, what do you think the defence would cross-examine witnesses on? And for if there are any prosecutors online, how do you prepare for this in evidence in chief of your own witnesses?
Josann, do you have any thoughts on this question?
In relation to the preparing for cross-examination or examination in chief?
Either, Joanne.
Well, with us in terms of examination in chief, we spend a lot of time actually preparing for trials. So with EIC, we have what we call our mind mapping, as well as our exhibit listing. So when it comes to mind mapping, the mind mapping and the exhibit listing, it goes hand in hand. It kind of acts as a guide, a summary for trial. But the mind mapping it's how would I explain this? I've done mind mapping so many times. It's so helpful. Like, it's not a summary in the sense that there's sentences. No, it's just main points that you would like to cover with a witness during your evidence in chief. And with the exhibit listing, basically what that helps, it helps the prosecutor to also keep on track with the evidence that have been tendered through each witness. But with that being said, we also anticipate issues that would come up during evidence in chief of a particular witness, like cross-examining questions that may come from the defense counsels. So if we anticipate that certain issues will arise in relation to a particular witness or number of witnesses, what we do is we actually go into trial prepared with case authorities as well, ranging from if there's any objections from defense counsels with regards to tendering of photocopied documents. And in terms of digital forensics, we've had an issue, one of our cases where defense counsel actually challenged the search warrant of the client's, the accused person's mobile phone. According to the defense, they said that we did not have the jurisdiction or the authority to execute rather the search warrant, because it should have been executed under a different law, which is the Cybercrime Act, which was enforced in 2021. But we found a particular provision in the Cybercrime Act that helped our case, so we raised that during court as well. So yes, so basically, just as other prosecutors would do, a lot of time and effort is put into trial prep, whether it be evidence in chief of your witness or cross-examining accused persons. So basically, with your witnesses, it's important that you not only keep your focus on what the evidence your witness is going to give, but at the same time, anticipate what are the shortfalls of the evidence, what issues or what from what angles will the defense counsel attack your witness's evidence, whether it be the credibility of your witness or the admissibility of a particular evidence that witness is intending to tender through. So yes, I hope that helps other participants understand. But yeah, just from what I've experienced in my line of work, that's basically how we prep for our trials. I mean, as fraud prosecutors, we have it's quite interesting this area of work, but at the same time it requires a lot of preparation. So preparation is key.
It's
Yeah.
very similar here in Australia in that we will, when we're preparing for trial, we will analyse those witness statements that investigators have given us for where we see weaknesses or gaps. And it may be that there are particular areas where we might get investigators to go and get more evidence, or if you're preparing as an investigator and you're taking those statements, or you think, oh, there is some further evidence we can get, such as Simon's just put into the chat, that a option is that some libraries you have to put in login details, and that's recorded, including what time you've logged into a computer. So that could have been uplifted at the same time together with the CCTV, so that you're then matching more times. So it's just filling in those gaps. Another strategy that we often will use is if we know there's going to be issues that defence will cross-examine, we'll ask about those issues in evidence in chief, and we will try and get out all that evidence in a controlled manner, as it's much more potent to be able to lead in evidence in chief any weaknesses and acknowledge those weaknesses. So from an investigative point of view, alerting your prosecutors to something that you perceive as a weakness or an area where you think that you might need to go get more evidence can be really useful. Sorry, and then what I was going to say is Patricia has written, the defence might challenge the CCTV footage and its reliability because it's fuzzy and the different time zone of that footage. And that's a great point there, Patricia, because if there is a different time zone on the footage, that's something that as investigators, it's really useful if you put this into your statements as to this footage is obtained in this different time zone. This is because the library's footage CCTV camera has never been updated to match this time. Instead, we found through investigations that the footage was running 5 hours behind. That then allows everyone to calculate what time the footage should be in. And it's just a nice, clear picture of why. But as Patricia rightly says, sometimes that fuzzy, you can't get better than fuzzy CCTV footage. But at the same time, fuzzy CCTV footage has led to convictions because a defendant has a particular facial feature, or is wearing a particular hat, or has a particular tattoo. So I completely agree with you, Patricia, that you could see it a challenge from defence, but then try and pick out what are some distinguishing features that you can use to still argue that the CCTV footage is relevant and is still reliable.
I just want to note that the bonus question is actually laid out on page 64 of the Lawyers and Judges workbook that you received at the start of the course, and page 67 of the Law Enforcement workbook in the CDPP's practice tips. So I would, if everyone could look at that in their own time, that would be great. Still very helpful, but I think we're going to move on.
If I
just
just
due to
might-
time.
Yeah, I'll just jump in with that bonus question.
Yeah, of course.
It's something that we all make errors. Every one of us will make errors in our prosecutions, in our investigations. We've all unfortunately done so. And so where that has happened and there's been a mishandling of those sensitive images or material, it's very useful when investigators email prosecutors saying, look, I've just gone through it, this is here, or if a prosecutor picks it up, liaising quickly with the investigators to then get a copy of the evidence that can then be quarantined and provided to defence, and defence provide back their copy that had the sensitive images. So just always make sure that you have that excellent open exchange, because we're all working as one giant team, even though we're very independent of each other. But it's very easy to miss something. But when you do pick it up, act quickly to make sure it's quarantined, and then making sure that those sort of sensitive images are handled in their independent way.
Thank you, Natasha, for that. That was great. So now we're going to move on. So I'm now very pleased to say that we have time for some remarks from one of our colleagues, Josann Pene. Josann Pene is a part of the State Counsel at the Fiji Independent Commission Against Corruption. Josann is also an intermediate participant of the Digital Forensics course, having completed the Fundamentals course in 2023. Today, she will share her reflections on working with digital evidence from her own career and share any observations she has from a lawyer's perspective as well. Over to you, Josann.
Hi, everyone. I'm glad that I had participated in the Fundamentals of Digital Forensics course. I actually learned a lot in that course as well. And I continue to learn a lot as well in the intermediate course, which I'm undertaking. This course it is actually relevant to my everyday work, my everyday line of work. And most, if not all, but most of our cases, somehow, one way or another, will have digital evidence involved. So we have our own digital forensic officers here in the commission. We used to have two, but one has now joined the Serious Fraud Office in New Zealand. So we're down to just one digital forensic officer. So just recently, I was in a trial where we had digital forensics as well, evidence. So the Defense Counsel challenged the material, the evidence which we uplifted, extracted from the particular mobile phone of the suspect, the accused person. There are a lot of challenges to that evidence in court, even to the point where defense counsels even questioned the legality of the search of the accused person's phone. So we managed to handle that in court as well. The defense counsel, he challenged on the basis that the search warrant was executed under the wrong law, and it should have been executed under the Cybercrime Act. But then we managed to handle that situation where we found a provision in the Cybercrime Act which actually allowed, which did not affect the execution of our search warrant into a particular mobile device. But another, it's becoming a sort of like trend now, where we also see that when it comes to digital forensics evidence, where laptops or mobile phones are pieces of evidence in a particular case, there's the issue of password. There we have had experience in the past where accused persons refuse to provide the passwords to access the for the officers to access the device, and they refuse on the basis that of right to privacy. And we also had a case where there was a ruling on that particular issue. So I would say digital forensics is now more than ever relevant to everyday line of work, especially if you're in the legal field and you're in prosecution field. Almost 90% of the crime will now involve digital devices. So yes, it's been a very eye-opening course for me, the fundamentals course. But then now that I'm doing the intermediate, I'm still learning more, not an expert yet. But one thing I would say is that having gone through these courses, it has helped me as a prosecutor to understand how digital forensics works, especially when it comes to the expert. Because as a prosecutor, before you put your expert witness on the stand, you yourself need to understand what his evidence is going to be about, and how to tackle the issues that will come across during the cross-examination of your witness. So yes, it has been very interesting, I would say. Of course, it will be challenging because not everyone is fully versed or well versed with how digital forensics go, but I guess that's the reason why we participate in these courses, to understand and to learn it. So yes, it's been an eye-opening experience as well, and I would recommend other prosecutors as well to also take part in this fundamentals of digital forensics course, because we live in an era now where technology is evolving, and crimes are not just restricted to just paper trail crimes. It's now evolved to digital as well. So for us prosecutors, for us fraud prosecutors as well, digital forensics is now becoming a more, I would say, common evidence for us in our line of work. But it's also helpful that we have our experts as well, who are well trained in that field, and when attending to extracting data from the whichever device it is, mobile phone or laptop, they are well trained, and they are experts in extracting those data and in maintaining the integrity of that data as well. We have a registry office as well that maintains all of our, basically, safe custody of our evidence, and we have a digital forensic office as well. I haven't actually gone down to look at the office, but the digital forensic officers have their own office with their equipment, where they carry out their work. So yes, in terms of my journey so far, it has been quite interesting, and I've learned a lot along the way as well. And I'm grateful and thankful that for Mr. Peter Hancock's and Mr. Michael James, who had taken time out during the fundamentals course as well to come on to the Zooms and help explain or even take us through their experience as well. So yes, quite an interesting
Awesome.
journey.
Thank you so much. Yeah, of course. Great to hear your journey, and thank you so much for your remarks. Really appreciate it. So now we'll move on to the second part of our session, which focuses more on the technical aspects of digital evidence and working with expert witnesses to explain some of the issues that may need to be communicated carefully in a courtroom. This does include a second session a bit later on, but before that, I'm delighted to welcome our second presenter, Senior Federal Prosecutor Natasha from the Commonwealth Director of Public Prosecutions in Australia. Prior to coming to the CDPP, Natasha worked as an associate to the judges of the Queensland Supreme Court and the Court of Appeal and interned at the International Criminal Court. She then spent 5 years at the ACT ODPP as a prosecutor. During this time, she prosecuted matters in the Supreme, Magistrates and Children's Courts and has appeared in hearings with child and vulnerable witnesses. She has worked on matters involving murder, sexual and family violence, and serious violence offences. Natasha is now Senior Federal Prosecutor in the Canberra office, managing large, complex team-based prosecutions, including child abuse material through to corruption and international money laundering syndicate. Over to you, Natasha. I'll just get up your slides for you.
Thanks, Cara. That's a far too detailed introduction. So while those slides come up, today I'm going to talk about first the admissibility of digital evidence, then the continuity of digital evidence and challenges that both investigators and prosecutors face with continuity and challenges to continuity. And then lastly, talking about trial preparation when there is digital evidence to lead in a case. And that also has implications for our investigators of learning how prosecutors are going to use that evidence can sometimes change how you obtain evidence. So talking about admissibility, digital evidence is increasingly becoming highly relevant to prosecutions, as Josann touched upon. And this might be because an offence occurred entirely online or relevant communications or actions occurred using digital technology. The classic case is that everyone now has a mobile phone, and on that mobile phone is highly relevant evidence. And there are several important steps that must be taken by police and prosecutors to make sure you can successfully use digital evidence in a prosecution. The first step is always, how is it relevant? It comes back to that seminal question of what is the relevance of that evidence? Now, one of the really important things that I sometimes think we all overlook, and I certainly overlook, is when you have circumstantial evidence. So both direct evidence and circumstantial evidence can equally be powerful. As an example, I worked on a case involving a home invasion where a 13-year-old girl had been shot. The entire case was circumstantial, and the phones of each of the accused were seized, and they had a third associate, and their phone was also seized. In the days leading up to the home invasion, there was an increase in phone messages and phone calls between the three accused. This is compared to previously, they had sporadic messages in the months beforehand. In the 2 hours before the crime was committed, there was constant phone calls between the accused. We were also provided by the AFP with a location data that had been obtained from the accused's phones. And so that showed the three accused in different areas of Canberra. And then at the time that the home invasion occurred, they were all in the same area where the home invasion is. Location data does have its pitfalls in terms of not being able to give a precise location. So this is location data is what we call telephone towers, and where data is pinged off, where phones ping off towers. Peter and Michael can probably talk about that later to much more detail if people wanted to know anything about that. But the usefulness of this location data was that it then meant that we have the accused in all different locations. They come together in the area where the home invasion is at the time of the home invasion. And then an hour afterwards, they had all split up and were in different parts of Canberra. And then two of them left the state and went to different parts of Australia. The next day, two of the accused changed their phone numbers. So as you can see, this all this circumstantial evidence, when put together, presented this overwhelming evidence that the accused were the ones that did the home invasion, given that evidence of constant communication between them, and then them all being there at the time. So one of the things I want to stress is don't discount the circumstantial evidence, and it is really about putting together that, I always say, it's a jigsaw puzzle. You put together all the pieces, and that's how you get that picture. Then turning to the continuity of evidence, as you've learned today, as you'll learn throughout your training and also your careers, it's important to able to establish the continuity of your exhibit. That is the evidence of the chain of custody of an exhibit from the time it's seized to the time you produce the evidence in court. And there's a case in Australia called Maude where the judge said continuity evidence is ordinarily adduced to eliminate or reduce the possibility of inadvertent error affecting the identity or the results of testing of an exhibit. So this was a classic case. It involved floppy disks, and this may show my age, but people might remember floppy disks that you put into the computer and they stored all your data. So floppy disks had been seized by the Western Australian Police Force from the accused's house. These disks were left in the computer crime section and weren't viewed for 10 months. There was no evidence of what happened to these disks while they're in the computer crime section. When, after 10 months, these disks were finally viewed, they contained images of child pornography. The issue at trial became whether the child pornography images were on the disks when they were seized, or whether some mistake, mishap, tampering of the disks led to those images being put onto the floppy disks. The problem was the disks hadn't been stored correctly, they weren't checked, they weren't under secure lock and key, and there wasn't that continuity and chain of custody. For digital evidence, particularly where a copy of data has been made, the prosecution must also be able to show that it's an exact replica of the item that's seized from the accused's house. This will be established by leading evidence to show the person who made the exact replica and that no one had access to the actual item that was seized. One of the judges in that case noted the following, which I regularly refer to, about continuity evidence. They said continuity evidence may sometimes be necessary because there is a genuine question about the authenticity of a sample or object, the movement of which must be traced to be certain that it has not been contaminated or altered in any way in the period between the moment of seizure through to the time when it is produced and identified in court, or through the time it was subject to analysis or inspection. The issue is more likely to arise when samples or objects are easily contaminated or easily alterable. The content of a floppy disk is easily, mistakenly, or deliberately alterable. Images stored on floppy disks are, in a sense, ephemeral. The issue is that that's very similar to what we now have with USBs, with downloads that are stored on hard drives, is that those images are easily alterable. They're easily able to be contaminated. So it's really important that you're able to prove a chain of custody of a piece of evidence and that that piece of evidence is stored in a secure area that people don't have access to, and that if necessary, investigators can say only Officer A and Officer B have access to this locked cabinet, and they're the only two people that could have accessed the device while it was being stored. Now, if we can turn to the next slide, I'll just go through some of the practicalities of achieving that and also how prosecutors can prove continuity in practice. So it's not going to be every time that you have a challenge to continuity evidence. How it's important that all that continuity evidence is disclosed on defence and provided to prosecutors from a really early stage. The reason why this is important is that it means that you can easily stop this being an issue at trial. So prosecutors may need to lead evidence, need to be given evidence of warrants, property seizure records. So our AFP will provide us a property seizure record of every item that they take at a warrant. Then the video examination of the inspection of a device. So these days, AFP officers often have body-worn cameras, and they'll activate those while they're going through a device. But I've also had circumstances where an AFP officer's body-worn camera isn't working, or they don't have it. And what they did was they had a colleague film using their mobile phone, the officer investigating and inspecting the device at the warrant. This allowed them to prove that they didn't tamper with it. It showed the evidence of what the police had viewed on the suspect's mobile phone at the warrant. And then the minute the warrant was over, they uploaded that video onto their systems and it was saved. Other things that might need to be provided to the prosecution then disclosed on defence include custody seizure records and statements from the individual officers who moved items. An important step after all this evidence is disclosed on defence is to inquire with defence whether continuity evidence needs to be led at trial or whether the defence will make concessions. If no concessions are going to be made, the prosecution knows it's going to have to prove continuity at trial. It's really helpful when you do have to prove continuity to have that evidence in a table. Then you know how you're going to prove continuity if it's being challenged. So you can see an example of that continuity table that I've done up here, which shows exactly what happened with the pieces of evidence and when certain things occurred with the pieces of evidence. So this is where, for example, your table might also include things like Expert Smith downloaded data from the suspect's computer. It's saved on the USB. Officer X then placed the USB in a sealed envelope and stored it at the police safe. Then Expert Smith gets it out of the police safe. He makes an exact copy. He provides that copy to Officer X to analyse. He puts the USB back in the police safe. Officer X then marked all the relevant evidence in the copy, and Expert Smith produces those relevant emails and data off the USB, off the copy at trial. Throughout that, we can then follow who has made a copy, where the evidence has been stored, who got out the evidence to make the copy, that the evidence itself was put back in a safe. And it just means that there is no area that defence can then target to say that there was an opportunity for that evidence to be tampered with. Another thing is checking that your corroborating statements don't have inconsistencies. If they do, proof your witnesses. For example, there may be explanations why there are inconsistencies between your statements, such as daylight savings time was not taken into account by one witness. Something that's really easy to forget in Australia is that we have very different daylight savings times. At the moment, there are 5 different time zones across Australia. So if you have an officer who is from Western Australia, they don't have daylight savings time. They may have forgotten that when they're in New South Wales, there is daylight savings time. This is a ready explanation for why 2 police officers may have been an hour apart in their evidence and why you need to lead that evidence to explain it. And disclosing that explanation on defence early on, pre-trial, means that that might not be an issue and you might not need to call the West Australian police officer to explain why his statement is out by 1 hour. Another thing that is often the case for phone downloads is that the time marking may be in Universal Time Code or UTC, and that it may still be in Universal Time Code and hasn't been adjusted to the time code that you're operating in your jurisdiction. For example, on the East Coast of Australia, depending on if we're in daylight savings time or not, we will be Universal Time Code +10 or +11. And you will need to check if your crime occurs when daylight savings changes, has that time code switched over or has it not? And these are all little things, but it may be something that readily explains why there's an inconsistency, and it means that there isn't a challenge to continuity evidence. So it's really important to always check that you can establish the continuity of your exhibits, ideally before laying charges or at least before going to trial. The really great thing is if you can cut out continuity of exhibits and digital exhibits before a trial, you greatly reduce the amount of witnesses that will need to be called, because all this evidence can then be led through an informant. The last stage in the admissibility of digital evidence, in my opinion, is the expert evidence. And this really ties into what Josann was talking about, which is how do you explain that evidence? The first step is determining if you need an expert to come along and give that evidence. At one end, you might have very basic evidence from a phone. For example, particular messages are sent between two participants. You might only need to tender screenshots of those chats, and that can be done through the informant or officer in charge of the investigation. You don't need a forensic report. You don't need an expert to come and say it, because it's just screenshots. However, if, say, once again, we have that date and time issue occurring, and that was instrumental as to when a message was sent, you then might need to call an expert or have your officer in charge, if they're qualified, to give evidence as to how a phone recorded the time and what time zone that phone operated in. So little things like that can then readily explain how your case comes together. And you then might need to have someone with more experience be able to give evidence as to how a phone works or how some information is recorded on a phone. And this is also through how investigators can then get that training, so that they then can say, yes, I've had training this, I understand how the phone works, and they can be the ones to give evidence. However, you will often need an expert to explain what the digital data actually means. For example, if you've got an image, like we have in this case, on a device, what can we say about how the accused engaged with that material? What conclusions can you draw? So by that, you might want to say, okay, well, the data on the phone shows that the image was taken on this time. The location data on the image shows this. The more you require that explanation, or what we call opinion evidence, the more likely you're going to need an expert. And so realistically, you've got to ask yourself, do I need an expert, or do I need a witness that can explain how the data is obtained, what the data means, how it's recorded? And then at the far end, which is often where my cases end up at the moment, is, do we need an expert to give evidence about complex computer and network data? I currently have a matter where we're prosecuting an IT specialist. And the way his computers and his internet systems are set up and the programs that he uses, they're not Word. They're different operating systems. He has different operating systems across his different computers. And so we've had to bring in 3 experts to be able to explain the different programs, how they're each set up, and what each program can record in the back end of that program that tells us about what the accused did on his computers at various times. Ultimately, you call an expert when you need that specialist and opinion evidence, and you want them to be able to give it based on their expertise, their experience, and their training. There are a number of challenges you can face when you're presenting digital evidence, and Josann really touched upon the first one, which is understanding the evidence. You really need to know your evidence before you can even decide what your case is about. And knowing how digital evidence works and what data is contained on a device is key to understand your case and how the evidence fits with it. You're only going to be able to ask questions from your witness or an expert, and what evidence you need to lead from them if you understand your case. For example, if you need to lead evidence about how an accused sent messages via the internet using the computer, you may need to lead evidence about an internet service provider. The first time I got an internet service provider in my brief of evidence, I spent quite some time on Google trying to work out what an internet service provider was. And it's an important step, is to educate yourself and then to start asking your experts and those that have technical capabilities, what is this piece of evidence? And the key thing I say to all our experts, and even to my investigators, explain it to me like I'm someone who's never seen the internet. So when you're giving that evidence as an investigator in court, think to yourself, how do I explain this to someone who's never seen the internet? How does this work? One of the key things sometimes is that this, and trying to figure out how does this work, leads you to the conclusion you need an expert in your case. Work early with as prosecutors, you need to work early with your investigative team to obtain a digital forensics expert and get their report. Those reports take time. Some key things to remember about when you have an expert is the expert doesn't belong to a particular party. Their job is to assist the court and the court in understanding. It's really important when you are briefing them to get their report that you don't suggest a particular finding or particular results. There may be particular rules around expert evidence in your jurisdiction. In New South Wales and in the ACT where I live, our expert witnesses have to have read a code of conduct. They have to agree to abide by that. They're required to provide their resume and set out all the training and background that they have to show that they're an expert. For some, we also get specialist police experts. So they may have worked in a particular field, such as digital forensics for years, and they've worked on hundreds of cases. And so that's how they build their expertise. Any correspondence or communication that is had with the expert should be annexed to their report. So if you're briefing the expert as an investigator, think about what the court or defense are going to say about your correspondence. How do you word what you would like the expert to do in an open manner that's not suggestive of the outcome, and that is also still professional in your language. You may know your expert. You may go to the pub outside of work, or maybe not the pub, with your expert, but in that professional setting, think about the language of that communication. Any communications with your expert will be generally disclosable. So avoid giving commentary or opinion on the report. Leave it to the expert. That said, it's also okay to ask for follow-up questions if you think the expert hasn't answered the question that you need, or if you have further questions. Just making sure I haven't missed anything. The next one, and this ties also into preparing your expert for trial. And that's where prosecutors should be proofing their experts early. And when I say proofing, meeting with them and really getting to an idea of what evidence that they want. Then we'll move to presenting evidence. So you need to remember, and this is also what Josann touched upon, is that when you're presenting to a judge or a jury, they may not have a knowledge of digital evidence. There was a famous murder trial in Queensland, which involved the accused meeting the victim on a dating application, something that we're now all starting to see. A jury member started posting photos to Facebook of attending court each day and said in comments on one of her photographs of attending court, "It's the big case in the media." The very senior judge who was overhearing the murder trial and then had to hear the application by the defence to discharge the jury in full had never heard of Facebook. The Crown Prosecutor, who was of a similar age to that judge, was struggling to explain how Facebook worked and how the jury member may have been communicating with members of the public about the case and why the jury may need to be discharged. Ultimately, it was a junior prosecutor assisting on the matter who had to explain to the court how Facebook worked, how likes and thumbs up worked. So never assume that digital evidence is common knowledge. Use the tech-savvy juniors around you to explain terms to you, to explain things in a way that will make sense to both judge and jury. And also so that you can make sure you're asking your experts appropriate questions. Make sure, and Michael's raised his hand, so I'm just going to jump over to Michael because this is Michael's field.
Another area you can try is Google the actual application itself. I have had this question from CDPP and ACT DPP before, and I Googled the information, provided it to the prosecutor, and I wasn't called because that information was publicly available.
Yeah, and also, once again, that's where Michael has shown where his source is, and also then being able to explain to the prosecution, who's then passed that on to defence, as to an explanation of how this application has worked. The other important thing is to make sure for the expert that they explain in their report any terms that they're going to refer to, such as what is an iPhone, if you know that you've got a particularly I don't want to say elder, senior, a particular senior judge, or you have things like what is an Apple ID, what is the cloud. These are all building boxes of the case, so that the judge, when you explain the critical evidence of a photo being stored on a cloud, can understand how that came about and why it's very pertinent to your case. That said, there's sometimes where it can be really good to present evidence in a simple format. So if you've got a chat conversation, it might be useful to convert that into just a simple table for the judge and the jury to look through, instead of wading through pages and pages of those sort of bubble messages that we see. So it's really important to think about how you're going to present evidence. And that probably leads me to the last point, which is these data-heavy prosecutions that we're starting to see. The problem is your suspect's phone generally has excellent evidence on it, or your accused's phone. The problem is the volume of data is an enormous challenge that we're all facing. Most phones are over 60 gigabytes these days, which is thousands and thousands of pages of data. From what I've been told by AFP, and Michael or Peter will correct me if I'm wrong, 1 gigabyte of data roughly calculates at 678,000 pages of evidence. And these days, most of the seizures that we get given of digital evidence from mobile phones or computers from AFP are terabytes in data, terabytes in size. And so we really have to think about how are we presenting that evidence, and how can a person sensibly review that amount of evidence. So part of the role of an expert might be in guiding you in finding that relevant information. They might be able to tell you which parts of the system to sort through, or they might be able to give you assistance through being able to do keyword searches on a device. Think about the best way to condense and present this information. For example, as you can see in this table, we often will present and condense it in a chronological table that gives an overall picture of what an accused did over a couple of days, and it combines information from a variety of different chats, as well as forensic accountant reports and other different reports. You might be able to add in things to these tables like location data, surveillance evidence to show where they were when a particular communication was sent. While a volume of data can be overwhelming, when you properly digest it and present it, it can provide such a comprehensive picture of what a person's movements and communications were that it can be vital to your case. Tying that back to the continuity that we discussed earlier, you then may need the expert or the witness to then set out how they came about producing that table, or how the data in your table has been analysed. For example, did they do keyword searches? What keywords did they search? That they made no changes to the data when they did searches. So it's important as well that when you are confining analysis of evidence to things like keyword searches, or you're not going through an entire device, that this is also disclosed on defence. Back in 2018, there was a case in which there was a significant disclosure to defence of material that had been obtained under TI warrants. But what happened was they had only done keyword searches, and all the other material was only told to defence while the trial was underway. This ultimately led the judge to discharge the jury and order a new trial once defence had had an opportunity to analyse all evidence. So the key thing there is to make sure that if there is summaries of evidence provided or only extracts of evidence, that defence are told that actually there is an entire phone download or there is this other evidence, but for these reasons they haven't been analysed, and giving defence that opportunity, if they want, that they can then analyse it themselves. So in summary, ensure continuity for all digital evidence, keep all records and disclose those records on defence as soon as you practically can. Know your evidence and how it was obtained, and then keep presentations of digital evidence to as simple as you can. It's powerful evidence that can lead to guilty pleas and easily convince a judge or a jury. And that is all, unless there are any questions. And Michael has helpfully said a standard Bible is 1 megabyte in size, and we're now into gigabytes and terabytes, just to give you the idea of how much data we're all dealing with. And then
Thank
if
you,
not,
Natasha. Oh, sorry. Thank you,
I
Natasha.
was just going to
for
say
such a
back to you,
great-
Cara. So there you go.
Such a great presentation. Again, if anyone has any questions or comments they would like to make, that would be really great. While I'm just getting up the other slides again.
I think just one more sort of comment, observation, just to tie together what Natasha was saying. You really can't put enough emphasis on that engagement between the prosecutor, digital forensics, and the investigator, having those conversations together about what is relevant to the investigation as well. I know it was touched on before, but the digital forensic examiner, you can't expect them to know everything about the investigation as well. They'll, as Natasha mentioned, they can definitely give guidance on where things are stored, how they're stored, what to look for, what not to look for. But at the same time, the investigator should be working very closely with the DF examiner, and same with the prosecutor as well. I've been involved in many jobs where I've got all the information available. I know where there might be some evidential data, but I still rely on the investigator to make sure that we get the most relevant keywords possible. Always try to get DPP or the prosecution involved as well, because they might have some particular areas of interest as well to pursue. Because in the end, as mentioned about data size, you can't be expected to look through everything that's on that mobile phone or that computer or that USB or those potentially 20, 30, 40 exhibits that have been seized. Obviously, down the track, if it's called for disclosure, then you'll make everything available for defence and potentially their digital forensic specialists to go through all that data. That's they're more than welcome to go ahead and do that. So having that consultation or that collaborative process between digital forensics, the prosecution, and the investigator can save a lot of time. It can definitely target your efforts on what is relevant to the investigation. And I've been in court where defence has said, I note, Peter, that there was 10 exhibits that were seized and that you examined. But how can you? Are you saying that you looked at every single file that was on all of these exhibits? And I would say, well, no, Your Honour, I only focused effort on these devices and these areas of interest based on the knowledge of the investigation and for other reasons as well. And given more time, Your Honour, obviously we can then spend effort looking at these devices in greater detail, but it would take approximately this many weeks or months to review all this data file by file. So once again goes back to that key consultation process where you can't just fully rely on digital forensics to know all the answers and provide all the evidence, because we know so much. The investigator probably knows obviously more about the investigation, and prosecution obviously knows everything about the investigation as well. So making sure you all get in the same room together can help go through that massive amount of data, much more quicker and much more efficiently. So just something to consider if you don't already have a good relationship with the investigators or with your local prosecution. I really encourage you just to sit down, have conversations, as mentioned before, just talk about concepts, use different examples, and just start to build that relationship, because it'll definitely help you in the future.
And just to add on Peter's notes, it's very important that you maintain accurate notes on what you've done. The times, the dates, whether you've handed it to somebody else, whether they've handed it back to you. You've got to keep accurate notes, because they'll go towards your statement, but they can also be disclosable to the defence.
Awesome. Thank you, Peter and Michael. Yeah, just stressing again how important that timeline is. So we'll continue. We'll move on to the second group discussion session. This session will build on some points from Natasha's presentation, because it is focused on presenting digital evidence and working with expert witnesses. In this next session, we will focus on the digital evidence in our case study scenario, and we will continue to consider where expert evidence may be required to fully explain some of the features of the new evidence obtained by the investigator. So in the Outlook invitation I sent for the Zoom session, you would have received the updated evidence brief by email. So now it is time to have that open to refer to in our discussions. The red text is where the brief has been updated to reflect further evidence which was gathered after your pre-trial meetings last session, sorry. In this session, you will decide where expert evidence from a digital forensics analyst may be required to explain some aspects of the evidence you are relying on in the case against Bob. Have a think about what some of the digital evidence in the case really proves, and how you might need that to help the judge and jury make some connections. For example, do you need to prove ownership or use of a device? Do you need to prove the content of photographs, given they would appear on several different devices? How would you explain the information about where Kai is logged in? Okay. So AFP and Natasha will help answer any of the more complicated questions you may have about digital forensics. So we'll get started on question 1. Natasha, feel free to jump in as before, which was great, but if anyone else would like to answer first, go ahead. So question 1 is, assume the judge in question has never been on social media and has no idea how Facebook works, like the example Natasha has given us. The jury are also from the general community and don't have any cyber-related knowledge. What are the key pieces of technical information that you need to communicate to the court, and how will you do this?
Has anyone got any ideas before I jump in? One of the things I've found is that where people don't have that expertise, so for example, I often think my grandfather can't operate a mobile phone except to dial someone. So how do we explain to him how this works? And what specific things are crucial to my case that I might need to explain and have someone understand? For example, here in this case, an example, we've got the need to prove, and what is very useful evidence is that the library has the same ISP address as the location where the photos were uploaded, and Kai's Facebook account was deleted. So I need to have someone to give evidence as to what an ISP is and what that demonstrates in terms of where someone may be located. And so these are the sort of things that you should be guiding investigators and prosecutors as to what evidence is going to be needed in a case and how you're going to have that explained. Other things might be the capacity of Facebook to have multiple log-on details and to establish how there was a link between Bob's access at the library whilst it's still also logged in on Kai's phone at that time. The other ones are the date and time data for Maria's photos and the browser history at the library. If you don't have audio at the moment, feel free to put your comments or your questions and answers into the chat. But it's once again, how do we get these complicated processes and pieces of evidence explained in a really basic way to make sure that all members of the jury, no matter where they come from or what their experiences with technology have been. My grandfather, for example, refuses to accept technology. And so if he's on a jury, how are you going to explain how this works so that he can understand why this is a crucial piece of evidence in proving that Bob did what he did? Peter and Michael might be able to talk more about ways in which, if you're an investigator, you can explain these details in a basic language. I'm sure they're really enjoying me throwing over to them.
That's
But
okay.
maybe Peter, if you want to go first.
I found, like with almost all statements and reports that I've produced over the years, when it comes to social media applications, it is or can be quite foreign to a lot of people. And I find the best way, obviously you can't go into the courtroom and, hold up a mobile phone and go through the phone and show how the application works, but in a way you kind of can as well. And just by doing, like simple screenshots of the application and just doing a walkthrough introduction of how Facebook works on your mobile phone, or how, Snapchat or Instagram, whatever works, just by doing screenshots of the device and showing how the account works, showing what the profile looks like, having some little call out boxes, pointing out to what this is on the screen. This is the home screen button, or this is where you access the profile, and then to show a screenshot of the user's profile. It might be the actual profile. It could just be a test profile that you've set up within digital forensics or as an investigator, but introducing the actual application itself in your report with screenshots and walkthroughs about what this is, how it works, is usually very well received. You can always go one step further and go further into the different chats and whatever, but also when you do your mobile phone extraction using Cellbrite, for example, as a tool, it may also extract out all of these chats that are on there as well. So just the way that you present your chats, you want to make sure that that information is quite easy to read with the back and forth, but also linking it back into those original screenshots that you've taken as well. Doing that real simple walkthrough using pictures and images is the best way to explain how something works. So in a lot of my reports, I like to use red sort of boxes and call out boxes to sort of draw the attention to what the important thing is on this page in this report, so that the jury or whatever isn't looking at a whole page of it could be all good stuff, but drawing attention to what's important can help explain what's happening in that image, or what's happening with that big amount of information you're trying to explain. So once again, just to explain how Facebook works, just by having your screenshots and pointing to what these things are, keeping it really simple. You might think it's too simple, but there's always going to be people in that courtroom that it's going to be pitched at the right level, and everyone wants to be able to easily understand how something works. And images and screenshots, I think, is the best way to do it. You can also include like video recordings, so you might not just want to show screenshots. You might actually have the prosecution put up on the screen a video walkthrough that's been recorded of how this application works. Once you start needing to get into the real technical information, that might be then when you start explaining in technical terms how this works or what issues might be. But to start with, just using screenshots is the best way to go with social media applications, because you can never assume that the judge or the jury use those applications. Michael, not sure if you got some other comments to make there about presenting.
Yeah, I was just going to jump in there and just two things. Building on what Peter said about videos, recently I've got a case involving child abuse material, and the accused used various programs such as Chat Random and Chat Roulette, and I wasn't quite aware of how they operated, and we knew that a judge and jury wouldn't. So we actually had the officer film himself going on to these programs. He then needed to blur parts of the video for obvious reasons, but it was a walkthrough of an officer logging on, showing that he used the internet to access this site, then showing what the site was. It then meant that it was a really easy way to present to the jury what this program was that the accused was using, how the accused was then able to access particular material through that program. And it was just a simple 2-minute video. And it meant that when the officer was in the witness box, we played the video. He said he made it. This is what he did. We played the video. And it's just a simple way of presenting a very complicated piece of evidence by allowing the jury to follow through. Michael has really helpfully said, Celebrite will display the chats in the same format that they are displayed on the device. So the account owner's messages are on the left and the other participants are on the right, which is a very helpful reminder for me as well, Michael. So thank you. And you might want to build on that as well.
Yeah, just on what you were saying with regards to recording the use of that app. One thing, I did a job where the POI, the person of interest, had uploaded some sexually explicit movies to Pornhub. So to work out how that particular app worked, because I actually created a fake account and looked at how does it work, how does the upload process work. So it's actually going in and looking at the app as well as the case officer in this case logged in and used by the sound of it, used the POI's credentials to create your own, and you can actually go through and have a look and work out how it works as well.
And building on that, it's really important that investigator, or that Michael created a fake account and wasn't using the accused account, so that you don't have any contamination of the accused account. So that's a really important thing, making sure that if you are going to have an investigator go into Facebook or go on and film a particular application, and it might not be something as complicated as that, but make sure it's done in a neutral manner, that it's not the accused profile. Or if you want to show the accused profile on Facebook because they were what several of our offenders always do and want to post some post that they attended this site on a particular day, that you're filming it from a neutral position as opposed to going into the accused actual login details. You're viewing it as the public would if you can. So just making sure that you set out how you've done what you've done. What login details, or if you've created a fake account. I created a fake account. I then went on. I was able to see this. I've made a video of what I did, and then you can see this. Then the next one is, on what grounds do you think defence could challenge this evidence? Did anyone have any ideas of how the evidence could be challenged in this case?
Just again, reminding everyone that we're looking at Article 2, illegal access, and Article 8, computer-related fraud. So I might just get those up while we think about that question. So this is Article 2.
Not to be,
Maybe not.
I'll go on.
Sorry. You go. I was just going to say maybe go through Article 8, computer-related fraud, just because we haven't touched on that yet. Just in terms of this question.
So with the computer-related fraud, there are a number of things that we're going to have to prove, including what was the loss of property to a person, the import, alteration, deletion, or suppression of that computer data, what was the interference, and how do you prove the accused's intention? So I think the first one we can look at is who's got the loss of property? Is that, and what do you think defence will go after in terms of what was the loss of property in this case? And it can be really hard. I find fraud offences can be particularly difficult because you've got to really think about, like, how are we conceptualising what a loss of property is? And can property simply be your right to your images being private? So are we looking at Article 8 being the loss to Maria of her images being private, or are we looking at it from the point of view of the loss being Kai's Facebook data being deleted? So there can often be multiple avenues in which you can frame a case under a particular charge, and they, as investigators or prosecutors, you might need to look at those elements of the offence and really break down what is the strongest way and the simplest way to present this evidence. And sometimes that's asking yourself, what are the grounds that defence can challenge this evidence? And here, it could easily be that if you were to frame it as Kai's Facebook account being deleted, there is no loss of property because we know that Facebook accounts can be restored, and we know that Kai restored his Facebook account. So then there's no loss, and therefore there is no offence under Article 8. But could you make an argument that there was a loss of property to Maria because she lost her images and the right to those images? I think it's probably a stretch in this case, but these are the things to think about, and think about your cases from a number of angles when you look at those elements of the offence. Another thing that they might challenge defence is, here you also have to have that it was fraudulent or dishonest intent of procuring without right an economic benefit from oneself or the other. How are we going to prove that Bob did what he did to obtain money from explicit.com? Particularly where the evidence is showing that the entity making the payments isn't necessarily explicit.com, and we're going to have to rely on circumstantial reasoning. And that's something that defence will go after. So what other evidence do we need to rebut this challenge to the case? And then we might just turn on to, what would an expert be required to give their opinion or explain a digital forensics process for this case? And we have really talked about that in some ways in terms of the internet service provider and the capacity of Facebook. But there are other bits and pieces in this case where you might need an expert, such as explaining message histories on Facebook, or at times that people logged in. Or the other one that really stood out is you've got that date and time difference. Can an expert come in and explain why you're seeing a date and time difference between the photos and the browser history on the library? So once again, it's really useful to get the elements of each offence that you're considering and think, which piece of evidence goes to proving this element? What will defence challenge? And is there evidence I can go and obtain? Or is there, as a prosecutor, is there evidence I can lead to rebut that challenge by defence? And then Michael has said a really interesting point. And here, as an investigator, it comes back to then going to looking at the explicit.com website to understand how it works and how they make their payments. And so then you go into that investigation of looking at how the applications and how the programs are working. And that's where you may need an expert, or you may be able to answer it yourself by going into these programs and learning about them, doing research, and then being able to lead that evidence. Michael, Peter, anything on terms of ways in which you can use an expert to stop defence challenges to evidence?
Just something very quickly, just to go back to how explicit.com works, is if you can work out, or if you know how the payment goes, you can actually subpoena or serve a warrant on the bank for their bank records. And yes, it was paid into this particular account. If it's going into PayPal, depending on the jurisdiction, you can go, like I know that there's a local PayPal office in Australia, and acquire those records as well, which can show where the money has come from. So that could then go towards showing that the obtained the benefit.
Thanks, Michael. Did anyone have any questions in relation to that aspect or in relation to anything to do with leading the evidence in the case? If not, I might throw back to you, Cara.
No worries. If anyone wants to pop any questions or anything or comments in the chat, feel free. Just want to say thank you so much for joining us all in today's session. I would like to give particular thanks to our experts from CDPP, so Natasha, AFP, Michael and Peter, and our own Pacific branch who have joined us for this session. Before we say goodbye, I'm just about to launch a poll in the Zoom session, and we would be really grateful if everyone could respond to it prior to leaving the session today. So I'm just launching that. If everyone, can everyone see that? Awesome. Thank you. We'd really appreciate your feedback. So once again, I do want to state that given the type of evidence offending in this case, it is important to consider how Maria might be experiencing the matter at this point. Her witness statement forms part of the case, and the defense will be scrutinizing her behavior within a relationship where she thought she could trust the other person. This may be distressing, and she may also need support from the prosecutor to keep proceeding with the complaint and help to ensure her interests are protected. If you are involved in a case of this kind, I would encourage you to consider support services you are aware of in your jurisdiction that might be relevant to Maria's situation. I also want to mention that PILON has been developing a set of regional guidelines for prosecutors and witness support officers to support vulnerable witnesses through the prosecution of sexual and gender-based violence offences. If you are interested, please keep an eye out for further announcements from PILON on when the guidelines will be soon available. So this is the final Zoom session for our cyber courses. I hope you found the content useful and interesting. The outcome of the trial will be shared in future weekly emails. Please keep an eye out. If you have any follow-up questions after today's session, please feel free to contact AGD. Thank you again for everyone joining us, and I'll let you get back to your days. Thanks so much.